few and interested. Probate is obviously something that we all in all states have to deal with, and it's different in every state. The laws are slightly different in every state, but all the states are facing the same issues. We have an aging population. Everybody's read about it. The baby boomers are now becoming the elder group, and it's putting a strain on probate courts and on caring for the elderly all over the country. The National Probate Court Standards were originally written in 1993. Professor English knows about that. He was involved in it. I was not even a judge in 1993 until after the standards went into effect. So I'll let him explain some more about that background. But I have been on the bench for 20 years, and so I have been involved in probate for a considerable period of time, and my court, being in Harris County, Texas, has a fairly large docket. Right now, I think I have almost 1,700 guardianships pending in my court. So we started the process, I guess, 4 years ago to update the National Probate Court Standards. There are a number of reasons why it was useful to do that. Court technology didn't exist much in 1993 and before, when the old standards were written. And in order to keep up with dockets, as if they just had a class in the last session about everything is paperless now. In many courts, there is no paper anymore. Texas is going to be that way after the 1st of January next year. So widespread implementation of court technology, promulgation of new and revised uniform acts, issuance of national recommendations regarding guardianship and conservatorship. And that points out a problem. In Texas, there are guardians of the person and guardians of the estate. In other states, there are conservators of the person, conservators of the estate. So part of the problem you have to have is a language problem, and we tried to deal with that by just picking what we were going to call them in the new standards. We wanted to deal with initiatives by probate courts to address problematic areas, including expansions of services being provided to court users and increased use of volunteer programs. We're working on establishment of state Supreme Court commissions on elders in the courts, and recognition of financial abuse in decedents' estates, trusts under court supervision, guardianships of minors, and conservatorships of adults. In my experience, you can only take care of the wards in your court if you have staff to do it, or if you have a very good volunteer program to do it. These goals that the other two gentlemen are going to talk about in more detail are designed to be something that they're aspirational goals. We're not saying you should all have all of that right now, but it gives you an idea of what direction you should be going in. Some courts, I'm blessed with having a staff of 9 people. So I have an accountant for the guardianship cases and an accountant for decedents estate cases. There are many courts that don't have any staff at all. And so it's very difficult to supervise the people that you're appointing to be guardians. And what is shocking, I think, to the public is that a lot of the elder abuse that is committed by family members. In fact, more of it probably by family members than not. So our goal in working on up the new standards was to try to have all the good ideas that we could, bring them together in one document. I don't remember how long the original standards were, but the new ones are 93 pages long. So there's a lot of detail, and I would commend it to your study. And there are several places you can look at it. It's online. There's a connection to it on the National College of Probate Judges webpage, ncpj.org. On the first page that comes up, you'll see a reference to the standards. You can click on that and get a copy of them.
There should be 30 copies in the conference office, too.
Okay, there are 30 copies, printed copies in the conference office if you want to go by and get one. I was not aware of that. Thank you, Dick. But really the concern is, how are we going to handle increased business as the population ages? Alzheimer's, as you probably most know, was not really recognized in the 50s that much. It was discovered in the 1800s. But most people didn't survive long enough for Alzheimer's to impact their life. Advances in modern medicine, better care and treatment of heart conditions, better care and treatment of other physical conditions has allowed people to live beyond their brain's ability to survive and take care of them. And that's been a good part of the business that's increased in the probate courts. As people age, they are unable to take care of themselves. And the court has to be able to take care of them and figure out a way to take care of them, has to figure out a way to find the people that need the help and get help for them. We wanted to promote, to the extent possible, given that laws are different in every state, some kind of uniformity, some kind of consistency, and continued improvement of probate court operations. As I said, these are aspirational goals. I was telling them at lunch today, I sat down with the county judge. The county judge is the probate judge in most Texas counties, and he's the chief administrative officer of the county, and is not a lawyer in 220 of the 254 counties. And we were at a class telling about how to look at a guardianship accounting report, and he said, I only have 15 employees in my county, including all 4 county commissioners, myself, the county judge, the sheriff, and the county clerk in the district. We only have 15 people. I don't know who I'm going to get to do this work. So it's a problem, and we know that. We knew that when we were writing these, but basically most of the people that were participating were from big rural courts that knew a lot and were already advanced a little bit. But the goal is to get to all probate courts. And around the country, there are a lot of courts, they're not specialty probate courts in 35 states in the union. And so we're trying to get something that all courts can use, even if they're not a exclusively probate court. One of the things we worked very hard on was to give examples of promising practices that were in existence in other courts around the country. It's just deals that worked, that were working in various courts. And so we have throughout the standards examples of promising practices. We wanted to give references to information that's available. The internet is a wonderful thing because of the ease in getting information. The 3 of us are probably not the best people to talk to you about the internet because it happened long after I started practicing law. But it's amazing to me the amount of information that's available online. And as I said, we wanted to have aspirational goals. We wanted to set a standard that everybody should aspire to try to get to in their court as much as they could. And it's going to apply to specialized courts and also general jurisdiction courts with probate jurisdiction. The National College of Probate Judges tries to educate probate judges, but it's difficult to do that when the probate judge is a general jurisdiction judge and he only has probate, or she only has probate duties occasionally. And with the problems with all of us in funding right now, it's hard to get money to travel to go get education somewhere about probate when you're only going to do a few cases in your term as a probate judge. So we're trying to get more information out about that, and the goals or the standards are going to be part of the way we're going to do that. So we have a set of guiding principles. We have a source of improvement ideas, basis for requests for needed budgetary support. And that's really important. If you can go to your county funding body or your state funding body and say, this is what's happening in other states, this is what we need to be doing here. I didn't just make this up. This was written by judges from around the country, and you need to look at this and consider this as a goal. As I said, I'm lucky. I have 9 people on my staff, and we're able to keep up, but it's difficult if you don't have that many staff members. And it's a tool for strategic change, a way to measure progress. We don't really have time standards in there, but we have the fact that you should keep track of the time standards and you should keep track of the length of time it takes for you to do various things. The biggest problem in a probate court is things and people get lost. If you don't have a way to watch all your files, you may have a ward that you just lose. The guardian moved them, and you don't know where the guardian is, and then therefore you don't know where the ward is. And if you don't have staff to watch, and if you don't watch it fairly carefully, you'll lose people. So this is a template for state probate standards also, as states are developing more thorough law. We hope that the probate court standards will serve that purpose. Dick?
I was just curious, how many of you are probate court registrars or probate court clerks? One. And how many of you are from general jurisdiction courts with probate jurisdiction? Okay, just wanted to get a sense of the audience here. I'm going to talk a little bit about how the standards were developed and some of the provisions that I think may be of interest to you, that may affect you, that you may want to grab onto to help improve the probate court in your jurisdiction. So who was involved in developing, whoa, how did I get back there? Let's see, there we go. Got it. Who was involved in developing these standards? It was a task force that included 6 members of the leadership of the National College of Probate Judges, the then president, the president-elect, the vice president, who is now the president of NCPJ, Judge Woods, and the incoming president, as well as 2 other members of the board. It included the president of NACM, first Jude Del Priore, and then Kevin Bowling served on the task force. It included a representative from the American Bar Association section on real property, trust, and estate law, and a representative of the American College of Trust and Estate Counsel. There were 2 primary staff members from the National Center for State Courts. I was privileged to serve as project director and reporter, and Dr. Brenda Eckert served as the research director. That's who. Now, what did we do? This whole process started off with a survey, with a web-based survey that was sent to all NCPJ members and all members of NACM. And it sought to define what are the key issues, administrative issues, facing probate courts today. And secondly, it tried to identify what are some of the innovative practices that courts around the country are using that may be applicable in other jurisdictions. We got a terrific response that helped to set the path for the revision process and provided the examples that are strewn throughout the standards document. The drafting process itself was iterative. A draft would be prepared, it would be reviewed at a meeting or at a conference call by the task force. It would be revised based on comments, sent out again, reviewed, revised. Each provision was examined at least twice, sometimes 3, maybe 4 times. So it was a very deliberative and careful process. And once a review draft of all the provisions was complete, it was sent out to the world for comment. It was sent out to all the members of NCPJ. It was sent out to the board of NACM, to the Committee on Elders in the Courts of the Conference of Chief Justices and Conference of State Court Administrators, to the executive committees of the section on real property, trust, and estate law, and the American College of Trust and Estate Counsel, to the ABA Commission on Law and Aging, to the National Council of Juvenile and Family Court Judges, particularly because it also the standards cover guardianships for minors, and to all participants at the third National Summit on Guardianship. And many helpful comments were received and helped to refine the draft and are reflected in the final version. So the result was a document that is divided into 3 chapters. The first chapter has 4 general principles. They will look very familiar to you because they are drawn from the trial court performance standards. And then a second chapter on general administrative policy and procedures applicable to probate court. And then a chapter on specific probate court processes and proceedings. There are 62 standards in all and 4 general principles. The standards were unanimously adopted by the membership of NCPJ in November of 2011 and were endorsed by NACM and by the Conference of Chief Justices and the Conference of State Court Administrators a few months later during 2012. And I'd like to organize my presentation regarding the contents, and the content specifically that may be of most interest to you, around the 4 principles that, as I said, come from the trial court performance standards. And the first of those principles addresses access to justice, talks about having open proceedings as much as possible, safe, accessible, and convenient facilities, the opportunity to participate in the process, that everyone coming to the court should be treated with respect and dignity, and that the process itself is reasonable, fair, and affordable. So what are some of the standards to implement those principles? The first I'd like to talk about is Standard 3.1.4. One of the key and often contentious issues that are faced in probate proceedings is compensation, often competition, but compensation of trustees, personal representatives, executors, guardians, conservators, and the attorneys that represent estates or incapacitated persons. What the standard recommends is that jurisdictions or states develop fee guidelines to help make this process easier, to help reduce the number of disputes or the extent of disputes, and where disputes do arise, to use mediation or other alternative dispute resolution processes as much as possible. So as court managers, you may be called upon to help establish a fee schedule, or to establish a fee dispute resolution process for your jurisdiction, or to help the probate judges and other probate court personnel to do so. Standard 3.3.1 and 3.3.2 provide that the petition for a guardianship or conservatorship should be reviewed at the time of filing to make sure that all the necessary information is included. Let's not have the process go down the line only to be sent back to the beginning because all the information wasn't there in the first place. Those standards also call for a more substantive screening of the petition early on to see if a less restrictive alternative than guardianship or conservatorship might be appropriate to deal with the problems of the respondent. Thus, in order to streamline the system and to help things move more quickly in your courts, you may be called upon to budget for, staff, and design such a review and screening process, and train the people who will be doing it to accomplish it quickly, fairly, and accurately. Didn't want to go there yet. Court visitors, a fairly standard part of any guardianship or conservatorship process is to have an investigation before the hearing. Send someone out, whether it's called a court visitor, court investigator, sometimes a guardian ad litem, there are all kinds of names. But the basic duty is twofold. One, to inform the subject of the proceeding, the respondent, what is this all about? You know, how do you fit into this? What can you do? And to be the eyes and ears of the court in doing an assessment of, is a guardianship needed? Is there a less restrictive alternative that might work? Could a limited guardianship or conservatorship be applied? Who might be an appropriate guardian? To be a neutral source, an objective source for the court to get this information. There are many ways of accomplishing it, through court staff, through the use of volunteers, through appointment from a committee. There are many ways. They're discussed in the commentary to the standards. But as court managers, you may be called upon to, again, to budget for, to train, to oversee the provision of visitor services. Same is true for appointments of counsel. There's provision in the standards urging that in most circumstances, not all, but in most circumstances, counsel be appointed to represent the respondent, the proposed ward, the incapacitated person, whatever terminology you use. Same for minors subject to a guardianship. Again, there needs to be some kind of regularized process, finding attorneys who are willing and able to provide these services for court appointments, setting the fees that may fall into your lap, that you may want to get a handle on and help the court with. Let's move on to some territory that I think will be quite familiar to all of you: expedition and timeliness. And the standards put a great emphasis on making sure that cases move through the system as quickly as possible with regard to fairness. So they make quite clear, standards 2.2.1, 2.2.3, 3.2.3, 3.3.3, that it is the court that is responsible for managing the timeliness of the process. It is the court's responsibility, not the lawyers. So court managers are likely to be asked to help implement or adapt the case flow management system for probate probate cases. And with a concern, with a need to identify those cases and those individuals that may require some special adjustments. Parties who have physical or mental disabilities, there's scheduling issues. There may be a time of day when the hearing should be set that are likely to maximize their abilities. Persons who are elderly, persons who are near death, cases that are unusually complicated, or cases that can be fast-tracked. What I'm saying is differentiated case management is not only useful in civil cases, in criminal cases, it's useful in probate court cases as well, and you can design a system that will help each case get the attention it needs, but not more than the attention it needs. Standard 2.2.2 calls for the development of time standards, either on a jurisdictional or a state basis for probate cases. It refers to the national time standards for state courts that were adopted by NACM, CCJ, COSCA about 2 years ago that specifically refer to probate cases, but they need to be, they need to be time standards that fit your jurisdiction, its laws, and its rules. The national standards are just recommendations. So again, you can facilitate the development of time standards for your court, and as importantly, the monitoring of cases to make sure those standards are being met, the design when you're implementing a new case management system to make sure that it applies well to probate courts, probate court cases, that has, it includes the necessary breakdown so you can track probate cases as well as you can track criminal and civil cases. The third principle addresses equality, fairness, and integrity. And you can see, hopefully you can see the various elements on the screen. They should all be familiar. The standards that address this area include some of the following. 2.5.1 calls for a referral of appropriate cases to alternative dispute resolution processes, mediation, family group conferencing, settlement conferences, arbitration. So court managers may be called upon or may take the initiative to expand the ADR services and programs already utilized in your court to include probate cases. In many jurisdictions, the ADR is only available for civil cases, for standard civil cases, but nobody thought of including probate cases. Many probate cases fit very well, or at least portions of them fit very well into a mediation or family group conferencing type of program, and should be utilized, and these programs should be utilized. Another series of standards, 3.1.2, and you see the other numbers on the screen, emphasize the need to make sure that fiduciaries receive some kind of training, orientation, information on what they're supposed to do and how they're supposed to do it. All too often, a fiduciary is appointed and really has no clue on what to do, what services are available, how to access those services. So again, this is an opportunity to expand the kind of training programs that you already have in your courts for volunteers in various other types of jurisdiction to include probate jurisdiction, to help trustees, personal representatives, executives, guardians, and conservators in learning how they can best serve the person or the estate that they've been appointed to manage. Examples of existing programs, and there are many, are again included in the standards, and I commend those to you. The final principle addresses independence and accountability. And looking at that list, I don't think I have to tell you very much about how you may play into this. Let me just tick off some of the standards here, and then turn the mic over to Professor English. Human resources management, the standards talk about the importance of implementing a human resource management program that ensures that all probate court employees are treated fairly, with dignity and respect. Standard 2.3.2 urges implementation of a budgeting process that accurately reflects probate court needs. Just like juvenile and family courts, probate courts have some specialized services that are not found in other jurisdictions that need to be included in the court budget and adequately supported, as Judge Woods talked about. To establish an effective financial management system. Many probate courts are floating off on their own, and they don't have the financial management system that they really need in order to respond to funders' questions and funders' concerns. To establish and manage and monitor an ongoing strategic planning process. Include the probate courts in the general court process, or for specialized probate courts to establish a long-term process, look ahead to where you want to go and how you'll get there. Design and adapt and implement a management information system that can adequately serve a probate court. Too often the reports that come back are not really designed for the very different probate court process. It's necessarily different, and the reports need to be put in that can help a probate division or a probate court manage itself effectively. A system for monitoring guardianship and conservatorship cases. In too many places around the country, it is impossible to find out just how many open guardianships there are, much less where the incapacitated person is, where the guardian is. I've lost track of them. I have been in probate courts where they duly tick off whether an annual report or an annual accounting has come in, but nobody reviews it, so you don't know if there are any problems there. There needs to, as the guardian in some sense is an extension of the court, and therefore the court still retains the responsibility for monitoring whether the guardian is doing a good job, whether the guardianship needs to be continued, whether any changes are needed. There needs to be a process. Volunteers can be used, staff can be used, a combination. Any of you who attended the program put on, that featured the Maricopa County court knows that they've developed a differentiated case management system, in a sense, for monitoring, looking at which cases have the greatest potential of problems and assigning the type of resources needed by the level of risk. It's a risk assessment system. There's several suggestions in the standards volume, but this is one of the ways that accountability can be enhanced. And finally, establishing a complaint process, because this is very much a people-oriented court. The cases often are long-term. They're not, filed, heard, and disposed. They go on for a while. Problems arise, and there needs to be some kind of feedback loop, both a substantive and a process-oriented feedback loop. So those are some of the ways that I would suggest these standards interface with court management. and tie into your responsibilities ways in which you can help improve the probate court process. And with that, I'll turn it over to Professor English.
Microphone fell off. So it's now back on. I had said I was going to sit, but I want to stand up. My role is a little bit different from the prior two speakers, and that is my task is to describe some of the legal developments that were taken into account in framing the most recent version of the National Probate Court Standards. The original standards were produced in 1993. They were a very important achievement. The revision is better. And let me mention some ways I think the revision is better, or maybe a better way of saying it, more useful for those of you managing courts. The 1993 standards dealt with guardianship of the person and conservatorship of the estate. Those are the terms used in the standards. Dealt with those topics in separate chapters, which I think is a very confusing approach. The revision deals with them in the same place, which gives you a better sense of how closely related money and personal issues are. The second thing that the standard does, we've been calling it best practices, but I don't think that's really a good enough way of saying it. It includes innovative practices in the courts. And so when surveys were sent out in preparation for these standards, questions were asked about how you do things, what is innovative, what is different, how have you creatively responded to particular problems. And so when you look at the whole standards, you will find on almost every page examples of new approaches, things that you may want to think about in your own court system. The third thing that the standards does that was not sufficiently emphasized in 1993 is it deals with guardianship for minors and talks about the interrelationship on guardianship for minors with the juvenile court system, with the family court system, and adoption. And I think that's a very useful contribution to these standards, and we need more attention paid to guardianship of the minors issues. How will these standards be used? Well, they'll certainly be used in framing court rules for those of you from states that do have detailed probate court rules. Certainly they can be used as a way for your own budgeting or your own planning. But these standards can also be used for purposes of statutory reform. So one of my other projects is I'm co-chair of the task force revising the Missouri guardianship laws. And when you read the probate standards, many of them are written almost in statutory language. And so this will be one of the models that we're going to be using. But let's talk about other comparisons or similarities between the current standards and 1993. The 1993 standards talk about administration of decedents' estates, but emphasize what has become the reality in most states, not all states in the United States, that decedents' estates are largely unsupervised today. That is, most estates are handled under independent administration or informal types of administration. And in fact, in terms of the size of the report, the number of pages, and also, at least in my state, what probate judges spend most of their time on, it's on guardianship and conservatorship issues. So both in the 1993 standards and in the most recent revisions, the materials, the guidance, just simply the length of the chapters on guardianship and conservatorship, much, much longer, more detailed than decedents' estates. So what are some of the changes in guardianship that were taken into account, at least initially, in preparing the 1993 report and since then, that were considered in the most latest revision? If we talk about guardianship changes in the United States, much of it goes back to 1987, which I didn't even put on the slides. Back in 1987, the Associated Press ran a national series of newspaper articles. That is not only national reporting, but local reporters commented on each state's guardianship system and noted some of the problems, of course, that we've talked a little bit about already today and that are addressed in the standards. Difficulty of monitoring, lost cases. I think we've gotten better on this than we were back then, but more thorough or less than thorough systems for assessing capacity. And so the 1987 AP report got a lot of attention. And so what happened in 1988, the American Bar Association, and it was just not the ABA, there were about 100 participants, including, I believe, Mr. Van Dusen here, got together at a resort in Wisconsin. I've always wanted to go there, called Wingspread. And so even though the official title of this report is some long, cumbersome name, although it's not, it's called the Guardianship and Agenda for Reform, it's come to be known by the name Wingspread. And what the Wingspread report did is it has influenced statutory reforms up until today, literally. A second source of guardianship law changes in the United States is the Uniform Guardianship and Protective Proceedings Act. Now, the whole act has only been enacted in about 20 different states, but every other state, including mine, Missouri, has picked up bits and pieces of what was initially a 1982 revision. And so when you go back to the 1993 report, you see extensive citations to both the Wingspread report and the UGPPA as it then existed. Okay, well, let's not focus too much on past history. What were the themes that were important in Wingspread and the UGPPA? Well, one was the emphasis on alternatives to guardianship. That is, if there are realistic alternatives, they ought to be explored first. And then a second theme was, if possible, if practical, and of course oftentimes it is not, but if possible or practical, there should be a preference for limited guardianship. Okay, what you will find today, and I think this is true of all of the developments now that I'm going to talk about over the last 20 years, is the emphasis on alternatives to guardianship remains, but has simply become stronger over the years. The emphasis on limiting guardianship to the need, which was present back in 1993, is again still with us today, although again the emphasis is greater. But if we look at the law of decedent's estates, it's very much the same today as it was back then. There is more independent administration, more informal administration today. But most probate courts, the statutes are not dramatically different today from what they were back in 1993. What the big difference is, and this is one reason you're at this conference, is of course the emphasis on technology, on electronic filing, not the masses of paper that I used to see when I practiced probate law in Chicago. The whole Daily Center would be overfilled with paper if they still used only paper filing. So what are some of the developments since 1993 that influenced the most recent standards or were considered in the most recent standards? Well, we have major developments in trust law that have occurred. We have the Uniform Prudent Investor Act, which is the law today in all 50 states, has changed how trustees approach the investment function. Now, of course, some of your probate courts deal with trust issues. Some probate courts do not deal with trust issues. But the Uniform Prudent Investor Act has influenced the law of guardianship, at least guardianship of finances, and also the law of decedents' estates. And so the Prudent Investor Act is cited in the National Probate Court standards. We also have the approval in 2000 of the Uniform Trust Code. Now, of course, the mere fact the uniform law is approved by the Uniform Law Commission, which is an organization of the states, doesn't mean that it's instantly enacted everywhere. And so the Uniform Trust Code, though, is the law today in 26 states, not all 50 states, but still that's a significant number. And I think two themes to take out of the Uniform Trust Code is, one, the emphasis, and I think the term I should use is greater transparency on the fiduciary duties of the trustee. That is, the Trust Code actually codifies the fiduciary duties of the trustee, and that's had a spillover effect to the law of guardianship in terms of property management, and also the law of decedents' estates. And also the emphasis in the UTC on non-judicial settlements. And so we talked a little bit about ADR early on, sort of as a general proposition. We're seeing that trend in trust law as well. But let's talk about guardianship and related developments. 1997, we saw the revision of the Uniform Guardianship and Protective Proceedings Act. And I think the way to describe it would be simply increased emphasis on themes that were already present. That is, an increased emphasis on alternatives to guardianship, that those should be explored, that there should be some finding that no less restrictive alternative is available before a guardian of the person or conservator of the property is appointed, and also an increased emphasis on limited guardianship. We saw in 2006 the approval of the Uniform Power of Attorney Act, which has since then has now been enacted in 14 states in full, but it's influencing changes in power of attorney law everywhere. And again, there are two themes that at least I see from the Uniform Power of Attorney Act. One is a greater emphasis on holding the agent accountable for acting as a fiduciary. And so there was great unclarity in the law as to exactly what are the duties of an agent. Uniform Power of Attorney Act spells these out in great detail. In a sense, they're very similar to those of a trustee, because both trustees and agents under powers of attorney are fiduciaries. And then the other emphasis in the Uniform Power of Attorney Act is to at least think about the problem of agent abuse. Doesn't solve the problem of agent abuse, which we know is getting worse, I think, every year. And the debate is over whether it's getting worse because more powers of attorney are being used or agents are becoming more abusive. But at least this act gives you some tools to use in a case where abuse may be occurring. And then another development in terms of the law and guardianship related topics is the problem of multi-state contacts. And so, used not to be as big a problem, but of course you have families living in multiple states, you have the individual under guardianship may have contacts with more than one state. The guardian and protected person might move to another state. How do we transfer the guardianship? And so on. And so in 2007 was approved a guardianship statute, but a very narrow statute. It only deals, and I'm sorry the name is so long, but the name tells you what it is. Uniform adult, doesn't deal with minors. Guardianship is person, protective proceedings is property, jurisdiction is all that it deals with. And so it deals with the issue of guardianship jurisdiction only, whether it's guardianship of the person or of the property, and that's since been enacted in 38 states. In addition to all of these statutes, there have been lots of studies. I already talked about wing spread. I'm going to get lost in all my wings here. In 2001, there was a conference that was called Wingspan. And then in 2011, there was another major conference, and there was, in fact, a proposal to call it Wing something. But thankfully, that did not happen. It was the third national guardianship, actually summit. And the result of the summit was a symposium issue of the Utah Law Review was produced. That's available online. And so what you will find, there's about 70 recommendations in that report, just like there's 70 or so recommendations in the National Probate Court Standards. And then there's a complete edition of the Utah Law Review that has articles explaining all of the standards. And wing spread was far more important, I think, than these final two because it was first. But both the Wingspan report of 2001 and certainly this third National Guardianship Summit, which is just completed, are having and will have an influence on the law. And so what are the themes of, and I'm a little bit behind here, I apologize. I got way behind. I kept talking. I apologize. What are some of the themes of Wingspan and even more so the third report? Well, I think in a way it's more of the same. Limited guardianship should be preferred where feasible. So simply a greater emphasis on that. Less restrictive alternatives should be explored before making an appointment. That is an appointment of a guardian or conservator. And then the final theme, and this was a bit of a surprise to me because most of my work is with elderly populations or elderly issues. But we have to keep in mind there is a whole community of professionals who work with individuals who are developmentally disabled, or the more modern term would be intellectually disabled. And a major theme in that community is called person-centered planning. And one way of understanding person-centered planning is where feasible, and of course it isn't always feasible, the protected person themselves should be in charge of their future. But of course, under guardianship, somebody else is empowered to make decisions for the protected person. So we have a tension there. And so I think in terms of guardianship, maybe the term really wouldn't be person-centered planning, but to the extent practicable, collaborative decision-making. That is the idea that we should, number one, take the ward's prior preferences into account, to the extent we know them, but also consult with the ward on current decisions. And so this certainly is consistent with the prior studies, but in a way is more of an elaboration, goes one step further than the prior reports. So where are some of the uniform law influences that are perhaps more obvious when we take a look at the standards here? Well, 3.2 of the revised standards deal with the law on decedents' estates. There's a need to cite models, example statutes on decedents' estates, and so the Uniform Probate Code, not necessarily more superior than the law in many other states, probate codes, but it's extensively cited in 3.2 of the standards. Far more notable, and this is true both back in 1993 and in the revision, is the citation of the Uniform Guardianship and Protective Proceedings Act in section 3.3 of the standards. And the closest correspondence by far between the Uniform Act and the probate court standards is section 3.4, dealing with jurisdiction, or more broadly, I'm calling it interstate guardianship. Okay, now this is not totally an accident. The original probate court standards were approved in 1993, but about 10 years later, they were amended to deal with guardianship jurisdiction type issues. And so the National Probate Court Standards, as revised, influenced the drafting of the Uniform Act on guardianship jurisdiction, and then in turn, the revised standards quote that Uniform Act. So that's a little bit of background on both the standards and some of the laws that have influenced the drafting of the standards. And I think, Dick, are we ready for questions?
We've been talking for about an hour here. Now your turn. We would very much welcome any questions, comments, concerns that you may have. Yes? And could you use the mic if you could, just so they can record it? By the way, this is what the standards look like. And you can have this copy if you ask me nice.
Sure. My question has to do with the movement these days to try and make courtrooms efficient, calendars efficient, and the need to prove up not only the need for guardianship, conservatorship, but also the specific powers that are necessary for that individual. And in general, there's a move towards almost a default nature for those proceedings. And was that discussed during the development of this? And if so, what was discussed?
Yes, it was discussed, and I invite you, Judge Wood, to chime in. In not every case does the scheduling need to work around a particular person's prime hours of attentiveness. So I think those are still the more exceptional cases. But it's mainly how to work it in. I think it was acknowledged that many guardianship cases are default type cases, as you say, but perhaps too many are. And there needs to be careful attention to make sure that default isn't assumed and that a fuller hearing is provided where it is called for.
The ward is facing the loss of all of his or her rights, and he should or she should be allowed to participate. In Texas, the law requires them to be present at the hearing. As a practical matter, over the last 20 years, probably less than 1% of the wards have been present. They've all said they didn't want to be present if they could talk at all. So you certainly, and I've had wards brought to the court on a stretcher by ambulance because they really wanted to be there. And the attorney ad litem made arrangements to get them there. So you can't get tied up in the idea, this is just going to be a routine, we're going to go through it. We have to appoint an attorney ad litem to represent them at the hearing, and we have to take evidence to make sure that I know that they are incapacitated. And I have a court investigator, the court visitor Dick was talking about, who does try to see if the family can make medical decisions for the person, and if all of their money is going to the nursing home for their care, there's no real reason to have a guardianship. The family can make medical decisions, and then so we try to do lesser restrictive alternatives. But you can't figure all that out if you don't have a hearing.
Other questions? Kevin.
Judge Wood, on behalf of NACM, I just wanted to say thank you to you and to the college for allowing us a seat at the table to participate a little bit in the discussions, even though many of us are not probate experts per se. A couple of questions that came up after the revised standards came out, I was faced with in Michigan, where I took them to our statewide Probate Registers Association, and they were intrigued with the standards and with some of the training that the college has done. And the question was posed to me whether the College of Probate Judges training sessions, your conferences, are just for your members, or because of the specified kind of probate training you do, could other people that are involved in this work attend? And if so, how could that be worked out?
Right now, they're for members only, but I'm trying to get that changed. We are now working with the National Judicial College to develop a training program for general jurisdiction courts that are going to be doing probate, that will be available probably mostly online, so that you won't have to travel to a meeting. You can get several hours of basic training in running a probate court online, and we're hopefully going to have something up and running within a year. But if you have some people that want to come, let us know, and I'll make sure you can get there.
All right. The follow-up question to that is, as you may be aware, Dick, I know you certainly are aware, historically NACM has not had a lot of substantive probate training as part of our regular conferences. But you did, I thought, a great job outlining in the standards all of the different ways these probate standards directly relate to court management and the various places it touches our lives in other places. So my thought would be, if there's some way that perhaps we could connect better in the future and get some ideas for what the college believes are important issues or trends in probate court administration, perhaps we can get that information fed into NACM's Conference Development Committee and perhaps provide some more robust training for people in the courts that have this responsibility.
I think that's a great idea, and we'd be happy to help in any way we could, either in planning or in presenting something like that. Probate is different than most other courts. Most courts, you have, whether it's a traffic ticket or a criminal case, there's the indictment or the information, and then there's a trial. In probate, there's the creation of the guardianship, and then there's the supervision of the guardianship for a long time. I have one guardianship in my court that was created in 1980, and the ward is still alive, and there's still a lot of work going on all the time. So it's not something that you can just say, okay, we're done with that when the guardianship is created. We have to supervise it. We have to read the reports that are filed, and if they're not filed, we have to show cause the person, and we're pretty good about that. We have a database where we can search and see who was appointed a year ago that hadn't filed their annual report yet, and then we can generate a letter, and we'll follow up, and eventually the sheriff will go out and serve them with notice. But it's different because it's so labor intensive to keep monitoring, and it's not really possible to do it just mechanically. It takes people.
The last comment I had was more to everybody that's in the room. Obviously, they expressed some interest in probate by being here, and a lot of our conference development work is based on what kind of feedback we get from members in terms of what's important, what do you want for future training, and if this is an area that would be of interest to you, please take the time to fill out an evaluation and say something to the Conference Development Committee. Otherwise, we won't see more probate topics on the schedules. So,
Great.
Thank you.
Thank you, Kevin. Other questions or comments? Well, I thank you for coming. On behalf of the panel, I thank you all for coming and showing interest, and our names and email addresses are in the conference material. If there are questions or ways that we can be of help to any of you, please don't hesitate to contact us, and look forward to the rest of the conference. Thank you.